Hi, everyone, and welcome to the Financial Ploys Patent Prosecution webinar. My name is Eliar Barazesh, and I'm glad to be moderating this webinar today. The panelists and I are excited to discuss this topic, and we hope that you find the webinar informative and enjoyable. So first, we're going to complete a few housekeeping items, and then we'll introduce the panelists and get started. This webinar is brought to you by Financial Ploys. You can read more about them on slide 2. Thank you to our co-producer, the National Law Review. You can read more about them on slide 3. And slide 4 contains a disclaimer. You're not our clients. We are not your lawyers. What we do here today is for general education and not for you to act on without appropriate advice. I'd also like to add that the views discussed during this presentation are not necessarily the views of our employers or clients and are made only in our personal capacities. So with that, let's meet the panelists, and I'll let each of them introduce themselves. First, we have Brian Landry of Sol Ewing. Brian, take it away.
Great. Thanks, Eliar. I'm Brian Landry, partner at Sol Ewing, LLP, resident in our Boston office. I have a broad-based intellectual property practice. I cut my teeth doing a mixture of patent prosecution and trademark prosecution. And as my career has evolved, I do more contested matters these days, enforcing and defending patents in district courts, the Patent Trial and Appeal Board, and the Federal Circuit.
All right. Thank you, Brian. And next we have Robert Rosenthal of Howard IP Law Group. Robert, go ahead.
Thanks, Eliar. Robert Rosenthal, Howard IP Law Group in Fort Washington, Pennsylvania. I have a prosecution and counseling focused intellectual property practice, focusing on mechanical and electrical technologies, including preparation of patent applications, prosecution, and related advice and counseling on patent and trademark issues.
All right. Thank you, Robert. And then, as I mentioned before, my name's Eliar Barazesh. I'm a senior associate with the law firm Baker Botts in Austin, Texas. I focus on patent prosecution and counseling, as well as post-grant proceedings and patent litigation. And I manage prosecution for a number of clients, so very interested to hear all the thoughts of our panelists today. And you can see our names on slide 5. We have full bios later on in the slides. Feel free to reach out with any questions you might have after this presentation. So I'm going to turn to slide 6 and just orient a little bit. So I'm not going to read this full slide, but as I mentioned, we're going to focus on patent prosecution today and hopefully share some perspectives that will educate folks on how to efficiently and successfully prosecute patent applications and ensure that a high-quality patent eventually issues. With reference to slides 7 and 8, this is actually presentation or episode 2 of a 3-part series. I believe you have access to episode 1 if you'd like. We discussed patent preparation in that episode. We're going to be talking about prosecution today. And in episode 3, that is scheduled for July, we'll be focusing on portfolio management. So with all of that, we're going to skip ahead a couple slides and go to slide 10. So we're going to level set and just discuss some basics. So the ultimate goal of prosecuting a patent application is to obtain a patent. Brian, can you explain to everyone what a patent is?
Yeah, so patents are basically exclusionary rights. What the goal of patent prosecution is, for a primary goal at least, is to obtain a patent with one or more claims, typically a number of claims, and those claims define elements. And basically, if you obtain a claim for a system that includes elements A, B, C, D, and E, then that prevents a competitor from practicing a product with a system having those 5 elements. They may be able to practice something that has elements A, B, C, and D, but not E. But as long as they have those 5 elements, they practicing, which means making, using, selling, offering for sale, would be an infringement and could give rise to liability.
Great. And moving to slide 11, Robert, there are a few different types of patents that are available. Can you talk about that for us and explain that?
Yes, absolutely. There are three categories of U.S. patents: utility patents, design patents, and plant patents. Utility patents are the vast majority of patents and are the most familiar. And those can be granted for new and useful processes, so generally a series of steps, a machine, an article of manufacture, which can be almost anything from a little widget to a computer memory storing a particular computer program, or a composition of matter, which is typically going to be a new chemical compound, a new pharmaceutical compound. And as Brian alluded to, those patents have claims which define the scope of the invention. Design patents don't have to be useful. They are granted for new, original, and ornamental articles of manufacture. So the key to obtaining a design patent is that the design be ornamental as opposed to useful. Those claims are defined by drawings of the article in the application. And the definition of article of manufacture is pretty broad. It's not just something you can hold in your hand. It could be a design of a building. It could be an icon on a computer screen. And the third category, plant patents, are pretty specific for the invention or discovery of and asexual reproduction of new plant varieties. So those will relate to things like a new type of rose or a new variety of apple.
Great. Thank you, Robert. And I think the conversation here that we're going to have mostly going to focus on utility patents and the process of obtaining those. But it's awesome just to hear about these different types and let everyone know that there's multiple different variations that folks can go after. So we'll move now to slide 12, and slide 12 shows really an overview of major milestones when prosecuting a patent application. So Brian, could you kind of touch on these milestones and give us a little overview here?
Absolutely. So starting at the left with the application filing date, this I would say is probably the most important date or set of dates in the patent prosecution process. And the reason for that is that in prosecution, both in the US and elsewhere in the world, patent applications are examined relative to prior art, which means, depending on the country, but generally other applications or disclosures that were made before the particular applicant's filing date and or priority date, if there's a priority claim. And so for that reason, once an application is filed, we generally can't add to it. We can file further applications, and sometimes we may have a application that claims priority to multiple applications because we file something in January, then in February. But each one of those is a very discrete date in time that gets examined, and either you have priority or you don't to a particular application. So although we're going to talk a lot about what comes after the application is filed, really, we always encourage our clients to think about each one of those applications almost like you're making a time capsule. It's really kind of your best chance to get everything in there. And if you don't get it in there, there may be limited opportunities to recite that subject matter later. So once we file an application, and this is really in the context of what we call a non-provisional application, something that gets examined there's yet another type of application beyond plants and designs called a provisional application, which is a kind of subspecies of utility applications. But once we file a non-provisional application, it will typically sit there at the USPTO for maybe often at least a year. Sometimes can be multiple years, and this really varies depending on the particular art unit that you've filed in, whether this is your first application for a particular patent family, and the general volume that the USPTO is handling. But it eventually will come up for examination. At that point, the USPTO examiner or an examiner in another country is going to look at the application. They're going to conduct a search looking for prior art, which means, in rough strokes, disclosures or patent applications that were made before the application was filed or before the relevant filing date. The examiner will apply that art to the claims, looking at whether the claims are anticipated, meaning that they're identical to the prior art or obvious in view of that. And they'll also look at a number of other different grounds for patentability, including whether the claims have adequate written description, whether they're enabled, whether they're sufficiently definite. At that point, the examiner issues an office action in the US that has a 3-month initial deadline to respond, which is extendable by up to 3 months with extension of time fees. And typically, our clients will respond to that. We try to be very careful, as we'll talk about, in how we draft that response, because this is all a public record that can affect the interpretation. Moving along to the third box from the left, the examiner may issue a further office action, often deemed a final office action. And there's different ways we can respond to that we'll get into, including appeals, requests for consideration, requests for continued examination, or RCEs. And then if at any point during that process there's not a response filed within a timely period, then the application can be abandoned. Or if the examiner deems that the objections and rejections have been overcome, the examiner can issue a notice of allowance.
Thank you, Brian, for that overview. And I'd like to throw a question over to Robert now. Brian touched on kind of the backlog and the number of months it can take from when your application is filed until when you get an office action. In your experience, Robert, what type of delay have you seen? Have you seen generally like across the board, or 18 months? How long does it generally take in your experience to get a first communication from the US Patent and Trademark Office after filing your non-provisional application?
Yeah, generally, it's somewhere in the realm of 18 months to 2 years, and depending on the particular technology area and how backlogged they are, even more before an ordinary application receives a first office action from the examiner. Now, there are some options for applicants to speed that up. There's a Track 1 procedure that involves filing an application with payment of additional fees and making sure that everything is completely done from a formal perspective at filing, which can give an applicant an accelerated examination with a goal to actually get to allowance or a final office action within a year. So there is an option for applicants if that more typical 18 months, 2 years, maybe more timeline really would result in some business disadvantage to the client.
Awesome. And I'm gonna stick with you as we move to slide 13. So here, Brian touched on file the application, and we've just discussed there can be a little bit of a delay before before an applicant receives a communication from the patent office. What actually happens at the patent office after the application is filed? Can you touch on that for us?
Yeah, the first step is there's an initial review for formalities and generation of a filing receipt that identifies all of the bibliographic information for the application. Most importantly, getting the filing date right. Hopefully the patent office gets that right. Inventor name, applicant name, and if this application is based on and claims benefit of earlier applications, that detail, those details are also correct. So getting that filing receipt and making sure it's right is the initial step after filing. The application is then classified. There are around 8,000 patent examiners who have varying technical expertise in different areas. They all have engineering degrees, degrees in chemistry, physics, and those examiners are organized into art units. And Brian mentioned art units. So those are about 10 to 15 examiners under the aegis of a supervisor handling a very narrow slice of technologies. You can imagine 8,000 examiners, each one handles a pretty narrow slice of technology. So the application gets assigned to one of those art units. The supervisor assigns it to an examiner, and it comes up on the examiner's docket. And then the examiner reviews the application and conducts a prior art search. As the slide mentions, it's around 10 hours of time that the examiner has. Varies depending on examiner experience. More experienced examiners get less time. Varies on technology. Simple mechanical technologies, less time. Complicated software technologies, more time. And then the examiner issues a written office action with objections and rejections. And then, as Brian mentioned, you've got 3 months to respond generally, and purchase more time if needed. Very often there's a telephone interview with the examiner before filing a filing response, because not everything can be completely communicated on paper. Then there's a response on paper, and typically, if the first office action was substantive, then the next office action will either be a final rejection, which gives, even though it says final, that you have options, and or a notice of allowance, which means that the applicant can simply pay the issue fee and receive a patent on the claims that the examiner has now approved.
All right. Thank you, Robert. And yeah, that's really good insights into kind of the process and what's going on behind the scenes. The application is filed. And turning to slide 14, Robert touched on, the various examining actions that might issue. We're going to drill down on that a little bit here. As slide 14 shows, an office action might issue, and there are different variations of that, non-final and final, depending on the point in examination that the application is at. But there's also something called a restriction requirement that might issue. Brian, turning to slide 15, can you tell us a little bit about restriction requirements and what those entail?
Yeah, sure. So restriction requirements are basically a workflow management tool for the USPTO. One of the things that I neglected to mention when I talked about the first step in the patent prosecution process when we file the patent application, we include a number of documents, but also, very importantly, we include fees. And there's a set of fees that are paid that at a minimum include filing, search, and examination fees. May also include some additional fees for, depending on how many claims there are, maybe additional fees if it's a track 1 application to go faster, like Robert mentioned. But from the USPTO's perspective, that they are paid a fee for the service of examining a patent application, and those fees certainly do impact how they manage their budget and also how much work they are willing to do. So from a fairly reasonable perspective, one could imagine that if you somehow drafted an application that included 5 different inventions, it would be very understandable for the examiners to look at this and say, well, your application claims a car, an airplane, a boat, and a vitamin. I can't examine all 4 of those inventions because they're just completely different areas of art that I'd have to look at. So therefore, what the examiner will often do is come back and say, please pick one for me to examine. Now, I gave a fairly extreme example. What more often happens is that as we're drafting the application, to use the metaphor or the framework I used before, we may say, well, we'll have one claim for a system that includes elements A, B, C, D, and E. We may also think that A, B, C, and E would be independently patentable. So we may take different approaches in the breadth that we present claims, or we may look at, for example, a server in one claim, or cite a server in one claim, a client in another, or a method of use. And oftentimes the examiners will look at that and say, well, you're trying to get a lot of different claims in front of me, so pick one. Sometimes there's the ability to get a claim rejoined. For example, we can often elect a system claim and then have the examiner come back and look at a very similar method claim. And then there's also, I'll just touch on this very briefly, something called species election requirements, which I think makes the most sense in the chemistry area. So sometimes you may say that you have a claim that recites a halogen as an element. And as many of us would recall from the periodic table of elements, there's certain halogen, there's only a well-defined group of halogens. So the examiner may say, please pick one of those. I'll just focus my search on that. If I think your claim's allowable, then the examiner has to go back and search that, search the broader claim. This is definitely a nuanced area of patent law. So this is really an area where your patent attorney can provide a lot of value in navigating this.
Yeah, thanks for that, Brian. And we'll move to slide 17 now, and now look a little bit closer at office actions and what those entail. So, Robert, can you tell us about the content that we generally see in an office action from a patent examiner?
Yes, the first office action is supposed to cover all of the issues that the examiner sees, both substantive and formal, in examination, so that you don't have piecemeal examination. In most cases, you will see prior art rejections under Section 102 of the statute. Certain claims might be rejected on the grounds that they're not novel. That is, everything that you have claimed is contained in a single reference. And the office action will map the language of the claim generally to particular sections or printed paragraphs, if it's a patent reference with printed paragraphs of the reference, so you can see the examiner's reasoning. Prior art rejection under Section 103 says that the invention as claimed would be obvious to one of ordinary skill in the art. And the rejection will generally have 2 or more references. The language of the claim will be mapped to the language of those references, and the examiner will include a rationale as to why it would have been obvious to make that combination. A different category is subject matter eligibility rejections under Section 101. In my practice, those are generally in software and business method areas, and generally assert that the claim is directed to an abstract idea, and there is nothing significantly more than the abstract idea within the metes and bounds of the claim. The more formal types of rejections relate to Section 112. Indefiniteness rejections under 112 may point out inconsistencies in claim language within a claim, for example, using different terminology where it's not clear what that refers back to earlier in the claim. A written description goes to whether the specification really showed that the inventor had possession of the invention as claimed. There may be differences in the language, or the language might be very broad. But generally, you'll see those after the claim has been amended, or in a subsequent application, like a continuation application, where an applicant has tried to get a little broader. Drawing objections are generally pretty formal. Things like reference numerals that are in the specification but not on the drawing, and those often relate to claimed elements that are not illustrated in the drawings, or at least the examiner thinks they're not illustrated in the drawings. Specification objections will relate to the use of language in the specification sometimes. For example, if there's a trademark used to identify a material, that would be objectionable. If the specification is missing a required heading or section, you might see a specification objection, or if there's something like a cut off sentence because of a word processing error or something like that. So yeah.
Great. So that is really, really helpful just for everyone to understand. And I think an overall theme, at least for the for some of those later objections and like clarity rejections under 112, is a lot of times those type of rejections or objections can be issued because they were just minor kind of clarity issues, things that have popped up when preparing an application, and those things happen. But I think it also goes to there's a potential risk that when applications are not properly prepared on the front end, that a lot more of those objections, and probably more seriously rejections under 112, can pop up and be challenging to address once the application has been filed and you're in prosecution. So that was a great overview. And we'll move over to slide 18 now and talk about, you're an applicant, you've received this office action, it has a whole bunch of these rejections and objections in it. What now? So an applicant generally will submit a written response to the patent office if it wishes to continue prosecution. Brian, tell us about these responses. How do you frame them, and what do you include in the responses to effectively address the office action and hopefully overcome it?
Sure. So the office, or the responses that we file, again, as I mentioned earlier, are part of the patent file history, which gets a lot of attention when somebody's looking to try to determine the scope of claims, whether that's in some sort of diligence for a transaction, or in a litigation or challenge to validity. So we definitely want to be careful and thoughtful in how we prepare these. One of the approaches that we try to take when we're responding to an office action is to basically make the minimal number of statements and changes that are necessary to overcome the response. There's obviously a little bit of an art to this, and we certainly don't want to write something that is so bare as to not be persuasive. But at the same point, we don't want to make extraneous, unnecessary statements that ultimately come back to haunt us. So what the responses typically start off with, usually there's a cover page that basically allows the office to figure out what this relates to. Probably a bit of an artifact from the days when all of these responses were filed on paper. Nowadays, probably 98% of responses are filed electronically and are automatically married with the particular application. Next, you would typically see amendments to the claims, or at least a listing of the claims. We sometimes will see amendments to the specification, to the drawings, to the abstract. Because of the way the USPTO handles all those need to be on separate pieces of paper. And there's different rules and procedures governing how that happens. And then the last part of the response is typically remarks. Usually what we try to do is track what the examiner did. We do that for a couple reasons. One, it's a good way for us to just make sure we didn't miss any issues. So typically one of the last things that I'll do before I file this is go down through the office action, make sure that I've addressed every issue that the examiner raised. Some of them we may, either, sometimes we may address at a fairly cursory level. Sometimes there's a pretty obvious amendment or response that we can make, and one thing that we do for one rejection may address something for another rejection. So sometimes it's pretty easy to say, we made an amendment and this is taken care of. Where we end up often spending the most amount of time is dealing with prior art rejections, particularly obviousness. And there, the number of arguments and the form of them really can vary depending on what sort of claim amendment was made and what the resources are that are available for the applicant. Sometimes it's as simple as saying, well, our claim originally recited A and B, and now we're reciting this feature C that was in the specification, but that wasn't recited, and the examiner really didn't do any searching for that. So we simply say the references don't teach this new feature. Other times it will be something where we will put in one or more declarations, possibly from the inventors, possibly from an expert, explaining why this combination of elements wouldn't have been obvious in view of the prior art. So it really depends on the goals, resources, and what stage of prosecution one is at.
Awesome. And I guess just as a follow-up, so when you file those declarations, how successful have you found that to be? Are examiners usually, fairly easily convinced, or is it very dependent? What's the general sense that you get from examiners when you put in one of those declarations?
Yeah, as with a lot of things for the USPTO, there can be a good deal of variance. That's a large reason that usually when I'm going to be putting in a declaration, first, the case probably has a decent amount of resources behind it, and because of that unpredictability, usually I won't just file that. What I would like to do first is conduct an interview with the examiner. We'll usually give them a draft of the declaration just to try to get some feedback. What we'd like to avoid is having to put in multiple declarations where we file a first one, the examiner doesn't like it, and now we have to get the declarant, whether that's an inventor or an expert, to say something else. We'd ideally like it to do it once and have it be successful.
Robert, do you have any experience with submitting declarations in that manner? Anything to add?
One of the issues we found in submitting declarations is that examiners will treat the declaration with the same relatively low weight that they would treat argument in a response. And the rules are very clear that a declaration by, generally it's going to be by an inventor, is part of the record and is given higher weight and for the examiner to simply turn around and say, no, I'm not convinced by that declaration, or I disagree on the facts, is not proper, and sometimes we'll have to go back and perhaps bring in a supervisor for a telephone interview in order to make sure that the declaration is given the proper weight.
Awesome. So we're gonna turn to slide 19 now and drill down like a little bit more into how the prior art rejections can be addressed. So Brian touched on one potential strategy, submitting a declaration. They touched on some of the arguments against the prior art. But Robert, can you go another level here and tell us, how do you approach prior art rejections, and what are kind of the steps you take to analyze an office action and formulate a response as to why the cited references do not teach the claims, and if they do, or if they reasonably could, how do you formulate amendments to overcome?
Sure. And as the slide suggests, the first step is always to determine whether the cited references in fact qualify as prior art. Generally under the current statute, it's looking at the effective filing date of the reference and the effective filing date of your application. And sometimes that's straightforward, but sometimes that's not. The examiner might have picked a patent publication that's one in a chain of applications, and there may be maybe the only application that predates your effective filing date is a provisional application. Then need to go pull that provisional application and see if the disclosure in the reference that the examiner is relying on is actually contained in that provisional application. And there may be some other circumstances where if it's and there are certain circumstances, if it's the inventor's own prior art and it's within the grace period, it may not, in fact, be prior art. But typically, the answer is yes, everything is prior art. And then, first of all, going through and making sure all of the claim elements are addressed, that the examiner has identified all the claim elements and has addressed those in the rejection, and then looking at how those map. Generally, when you're drafting the application, you're thinking about a certain universe of prior art, and sometimes the examiner brings in something that's a little bit out in left field. One of the issues to consider is the way the examiner is reading your claims and saying that they were disclosed by the prior art is within the broadest reasonable interpretation of the claim language. Examiners will tend to interpret claim language very broadly, and one area to push back on is to say that the broadest reasonable interpretation of a claim is less than what the examiner has thought it is. In some cases, you may say that, yeah, there's some amendment here. The examiner has a correct 102 rejection or correct 103 rejection, and some modification of the claims is necessary. And if it's a 103, if it's a combination, consider whether the examiners really articulated a proper rationale for combining these two references. They may be really picking and choosing features from the prior art without really giving consideration to whether it would have been obvious to the person of ordinary skill.
Yeah, there's some great great insights, and I think it's interesting just at the outset, like looking at are these references actually prior art? I know I think it's happened a couple of times, and when I've been looking at office actions, is that like you spoke about a few examples. One example I've seen is reliance on a continuation in part publication, and it's the continuation in part date that does not qualify as prior art. It's like the original application date that would be the prior art date, and they're only relying on the new matter that was added in the continuation in part, and that's kind of golden if you can find some sort of deficiency like that. No arguments on the record, just kind of are about the prior art, and just saying that this rejection is deficient because there's no prior art actually cited here. So I think it's important that you mentioned that, and those insights make a lot of sense. So
Yeah, that's a great point.
I think now we can drill down a little bit onto claim amendments, and there's kind of a lot of things to consider when you're thinking about how you're going to change your claims. Claim amendments are taking the claims that are pending and then making modifications. So usually adding subject matter to those claims to hopefully distinguish over prior art. So, and we've moved to slide 20 here. Brian, can you tell us a little bit about what folks should consider when they are amending claims?
Sure. So probably the best way to think about this is to fast forward to assuming that your application is going to be allowed and you're going to obtain a patent and then want to potentially assert it against somebody for licensing or litigation. What we do when we look at that, whether we're drafting a complaint, preparing claim charts for litigation, or trying to identify infringing products, is we'll go through the claims and we need to show that each and every element of that claim is present in the accused product, either literally or under what's called the doctrine of equivalence. And so the goal, or one of the goals of drafting and amending claims during prosecution, is to keep the claim focused enough that you can overcome the prior art, but still broad enough that you can read on relevant products. Oftentimes that's going to be the applicant's own product, because you want to protect somebody from coming in with really a pure copycat. But oftentimes you want them a bit broader than that, so that you don't give a competitor an easy design around avenue, where basically if somebody can omit a particular element, now they're clear of the patent claims. So that's something that can and absolutely should be done during prosecution. Obviously, it can be very challenging to make predictions about the future, to paraphrase Yogi Berra. But as much as you can, you really want to think, from my perspective, I try to think with my defendant's hat on. And if I'm representing somebody, what feature can I get rid of to avoid this? What feature can I say, well, we don't have this because this particular element has a very specific meaning and we're doing something different. And you try to iterate on that during prosecution.
Yeah, and I think you hit on a really good point. It's a balancing act, essentially, of you want to, if you need to amend claims, you want to obviously overcome the cited prior art, but at the same time, you don't want to narrow the claims so much to do that you're eliminating potential infringement targets. So this is another one of those decision points that folks have to make to figure out, what's the best way to amend claims and kind of maintain that balance moving forward. So moving to slide 21, and Brian, you touched on this a little bit, but Robert, it would be great to get your insights too on kind of that infringement aspect of when you're amending claims. What considerations regarding infringement should applicants keep in mind, and how should they approach that issue when they're making these modifications to their patent claims in prosecution?
Yeah, absolutely. The goal is always to have claims that would be infringed by a competitor. And directly infringed by a competitor without having to rely on doctrines like induced infringement or contributory infringement. If, for example, your claim is in practice only going to be infringed by an end user, say you have a new kind of oil filter, but you've got a claim that says you've got to replace the oil in the system before installing the filter. You might be creating a claim where the only people who are directly infringing are the end users. You want to look to whenever possible someone who is either your competitor or potentially someone else in the commercial chain that would be infringing. With a multi-part method claim, for example, in say a lengthy claim that involves a series of data processing steps, you do want to look for, if you can, a single entity that that would be infringing at least the broadest claims, so that you have someone to point to. Maybe there's something you can do to massage the language so some of the steps can be claimed inferentially, so that no one has to actively perform those steps in order to create infringement. And certainly taking a look at the Akamai v. Limelight decision, that's the en banc Federal Circuit decision. There was a lot of litigation, so there are a lot of cases out there, but looking at that to see if at least if nothing better, you'd have an argument that even if some of the steps are being performed by another party, there's sufficient control by your targeted competitor that you would have an infringement or really direct infringement under the Akamai precedent. And as the slide warns us, the law may change. So having a variety of claims that can provide a couple of different paths to infringement can be very helpful if there are sufficient resources, for example, to have more than the 3 independent claims that the basic filing fee covers.
Right, and yeah, great insights on considerations for amendments there, and how we should think through any of those modifications. So moving to slide 22, we're now going to switch gears a little bit, but focus on another rejection that might be an office action, and that's section 101, subject matter eligibility. Brian, can you talk to us a little bit about responding to those type of rejections?
Yeah, absolutely. And as with a lot of topics here, this could be its own hour-long presentation and then some. But although the slide, the quote of section 101 in the slide suggests that the scope of patentable subject matter is pretty broad under U.S. law, courts have read in an exception, which you see at the second through 4th sentence on the first bullet point there. Basically, the courts have recognized certain exceptions, such as abstract ideas, natural phenomena, or laws of nature. Now, lots of inventions rely on gravity, for example, to operate, and that's a law of nature or a natural phenomena. Similarly, there's lots of things in our body that have different correlations. But what the courts and what the USPTO are often looking for is whether there's something significantly more than those exceptions. So this comes up in kind of two ways. One, as we talked about at the beginning of the presentation, we can only point to and bring in things in the specification that were originally there when the application was filed. So you definitely want to be thinking about Section 101 when you're drafting your application and trying to lay out as robust of a technical story as you can. And then when we're prosecuting the applications, it's kind of two different ways that we can think about responding to Section 101 rejections. One is by trying to tighten up the claims, similar to what we do for prior art. The other is by trying to emphasize that sort of technical story. Because this is still, even though the Alice decision that really made Section 101 rejections robust came out over a decade ago now, this is still an area where the courts and as a result the USPTO are still trying to adapt to what the case law is and how it's going to be applied. I really find this is an area where you get a lot of bang for your buck in terms of paying the money to do an interview, have your attorney or yourself do an interview with the examiner. I've had some cases where we've had just some really bruising rejections where you would have thought we were dead in the water, and we interviewed it as a last ditch effort, and the examiner could not have been more helpful. One thing to keep in mind is that the examiners are dealing with this day in and day out and are probably dealing with this in some art units like software. They're probably dealing with this multiple times a day. Whereas for those of us that may do a decent amount of mechanical work, as well as different computer implemented inventions, we may see a couple, maybe a couple of these a week, if you're a particularly busy associate, maybe a couple of these a month, depending on the nature of your client base. The examiners really do have a good sense, not only for what the office is looking for, but also what their supervisors are willing to allow, because these cases generally do go through some review. So mileage varies depending on the examiner, their resources, but you may be pleasantly surprised in the examiner being practical and providing some really good suggestions.
Yeah, all really good insights, and kind of goes to that theme that I think we'll touch on a little bit later, but just developing a good rapport with the examiner and getting that feedback can really be valuable. So moving to slide 24, just touch on this slide, Robert, if you could. Section 112 rejections. How do you approach responding to those types of rejections?
Yeah, generally, when you're talking about Section 112 rejections for lack of clarity, it's a pretty straightforward task to change a inadvertent V to an A or vice versa. You do have to think about how you're changing claim scope, but often those are fairly straightforward. The Section 112 rejections, though, that are under Section 112A, where the examiner is saying that there's generally it's a written description issue, or there's a failure to teach the how the invention is performed. Those will tend to be more complicated, and there are a variety of approaches. One is to argue that actually the level of ordinary skill in the art is higher than the examiner was giving credit for, and that therefore some relatively brief or general language in the specification is sufficient to provide written description support for the corresponding claim language. Now, of course, that you have to be careful about that, because if the level of ordinary skill in the art is higher for you overcoming a 112 rejection, you have to be concerned about whether you're somehow making it easier for an examiner to make a 103 rejection by raising the level of ordinary skill in the art. Even in some cases, we've introduced evidence of the state of the art at the time of filing the application, particularly in continuation with a long chain to point out to the examiner that yes, as of an effective filing date that was 6 or 7 years ago, this description would have granted one of ordinary skill in the art sufficient basis to practice the invention.
Really, really good insights. And with that, we've kind of covered all the different bases of what we might see in an office action. And we would respond to that office action and hopefully obtain a notice of allowance from the examiner, or potentially in that same office action, the examiner might identify that certain claims are allowable. So, Brian, in these situations, how do you recommend proceeding when you have allowable claims?
Yes, so similar to the conversation we had earlier about what we look for in claim amendments, what we recommend considering is, are the allowable claims something that is of value? And oftentimes the notice of allowance is a very, very positive occurrence. Sometimes we will get notices of allowance or notices of allowability as part of an office action where the allowable claims just are pretty clearly not of great value. And, you know, although it's certainly nice that the examiner indicated they're allowable, I don't recommend kind of a knee-jerk response and automatically taking every claim that is indicated as allowable. I know some attorneys do, but it's really much more nuanced, and there are costs to getting a patent to grant and then ultimately maintaining it. So I think it always goes back to what value it provides to the business.
Makes a lot of sense. And turning to slide 26, Robert, talk to us about continuation applications. This is a type of application that is available to be filed that basically obtains the priority date of the currently pending application. Is that something that you would consider after getting a notice of allowance and to continue prosecuting new claims related on that same original disclosure?
Absolutely. It's always something that we advise the client to consider. It's generally only going to be if the subject matter is important to justify the additional effort, but there are a number of situations where it can be very useful. If you have corresponding applications pending in foreign countries, you may get prior art from those foreign countries that wasn't considered by the U.S. examiner. If you have a continuation application pending, that's an easy way to get that prior art considered by a U.S. examiner and obtain a second patent that is stronger than your first patent, because you've gotten additional prior art considered by the U.S. Patent and Trademark Office. You may, we always take a look at the reasons for allowance, and sometimes you can actually look at the reasons for allowance and consider whether the way the examiner is phrasing it is suggesting that some of the limitations that you have in your allowed independent claims don't really need to be there. So it may give you an opportunity to file a continuation that pulls out some of the independent claim, some of the language from the independent claims, and gets a potentially broader subject matter. You also want to look at kind of what the business environment is at this point. It may be that the client is actually starting to see some potentially infringing activity, and might even see some product out in the marketplace that appear to have been designed in a way to try to get around your patent application. We haven't discussed it, but U.S. patent applications are generally published at 18 months. So you may want to have a continuation filed with claims that are particularly directed to products that have been designed around, or you might want to have claims that are narrowly tailored to competitor products, so that you have claims that are narrower, harder to defeat in terms of prior art, and can be used in enforcement activities.
Yeah, all really good insights and things that folks should think about. And I know we're running up on time, so I'm gonna just skip ahead a little bit to slide 28. Obviously, one thing that can happen is that you receive what's called a final office action. And I think we touched on that a little bit earlier, but this is basically when you file your response, the examiner isn't convinced, and either maintains the rejections that were in the original office action that the examiner issued, or if you've amended claims in your response, finds a new ground of rejection, but is still able to make a final office action because they're necessitated by your amendments. And when you get to that point, it's called final, but there are options. So we have it listed on slide 28 of an after final response, a request for continued examination, which is essentially starting the prosecution process again. From like restarting prosecution, you have to pay a fee. And then there's also the appeal, which is appealing the examiner's rejection to the Patent Trial and Appeal Board for proceeding there. So those are a few options that are available at that stage, and something that, choosing which option to proceed with takes thought, and that's something that, a worthwhile discussion with your patent attorney as an applicant to figure out which way to go. And just to wrap up here, rapport with the examiner is important. I think we've touched on it with interviews, and just this is all about communication with the examiner to convince them to allow a patent application. So, and this is on slide 29. And this is just another thing that I think is vital and should be considered when prosecution is proceeding, that you're talking to a person at the patent office. It might just be on paper for a lot of it, but there is a person who you're interacting with. So just trying to keep that relationship positive, I think, can go a long way. So with that, we've reached the end of our presentation. We hope that everyone found this webinar informative, and hopefully we can see you again next month for the patent portfolio management episode. So thank you, everyone, and goodbye.